Alright everyone, as you can see, this is going to be a big one. There's even more information up here. Now we're moving on to Article 6, right to a fair trial. Now I should be adding, so far I've completed Articles 2 to 4. I should just add in the past few days I've been lagging a little bit, so if any of the videos from Articles 2 to 4 was in any way in low quality or it felt like it wasn't enough, please let me know. I'll either add updates to the Reddit forum, or I will make a new video or a supplementary one, depending on how much information people can gather for me to look at and confirm that it needs to be more extensive. I say this mostly because of how Article 6 sort of shocked me with how little I had to go through in the previous articles. However, it was always going to be the most informationally dense article. I'd say at least one of them. I'm guessing when we get to Article 8, maybe that could be argued. 9, 10 as well. 11, not so much. But yeah, for us to not get a headache, let's just zoom into the parts which we're working with now. First, autonomy versus subsidiarity. Pretty much independence versus the voice of the people. Since we're talking about a fair trial, what we're discussing is the autonomy of a court. Meaning we're not moving too much into subsidiarity issues. Rather, we just assume that we've placed all of the right systems to guarantee that everything that's been put down as a rule, meaning law, has been subsidiary. Meaning when an autonomous organ begins working within these frameworks, it remains subsidiary in its manifestation. However, in its procedure and how we fill out the last step of a court case, that's how you should look at it. If you have a system of filtrations or a system of steps, where you start from the law being written or being voted on down to the point of where it's consequential, you're always going to have to find yourself with courts needing to answer how these ideas, which are supposed to be subsidiary, actually work in practicality. And this is where it can get a bit controversial. The autonomy of a court could easily be used as a dispute for how their own ideas are not correct. However, the Convention of Rights has made sure that they sort of have established a relationship with each member state's court. Usually there's 3 instances up to the Supreme Court, which every state has. Sometimes you have parallels, sometimes you don't. But pretty much most of the courts which are active within Article 6, before these nations even ratified everything, I'm pretty sure the courts already established how these courts should be autonomous, but also not too corrupt. So we're going off the idea that the court already knows how these things function. And you could look at Poland and Hungary and say that they're still keeping up with updates. However, if anyone is watching this video and they've seen my other videos which work outside of doctrine, but just my own investigation on case laws, that's not quite the case. The issue is that Article 6, the right to a fair trial, doesn't sort of protect people from precedents being set by case laws. Meaning, by all irony, the idea of getting a fair trial means letting other people have their fair trial, but those fair trials set a precedent for the next time someone has the same issue. Meaning someone is having, or people are having fair trials, which are setting up case laws with precedents which are technically diminishing the protection bandwidth of the Convention and of the EU. I'm going to go into this in another video, but it's just important to know that the things I'm getting into now, they are being slowly but surely diminished in being powerful. We're having more and more cases, specifically for immigrants, not aliens. If you want to call them aliens, fine. I'm not calling them aliens. Immigrants are going to get less and less rights in Article 6, to the point of where it doesn't really exist for them. It's a good thing to know. If you don't care about immigrants, that's fine. But if you're going to be a jurist, you should know that they, legally speaking, have no rights. Successively, at least. There is no actual system right now which is trying to stop this succession. Meaning, things are slowly but surely leading to that point. Meaning, from my own perspective, as an individual, meaning if anyone disagrees, then we are as individuals disagreeing on this. But I'm saying, with how things are moving at this point, immigrants don't have any rights. If you can't stop things from moving forward, it means you never had a right to begin with. Now, hopefully this videos or any other type of forum will begin making these things more clear, especially with how the US is disillusioning the West by its own idea of being immune from pre-World War II dictatorships, fascisms, and so on. But yeah, it's just good to know. The right to a fair trial, it's not going to mean the same thing 10 years after this video was posted. Not if things continue as they are. And surely 10 years ago, Article 6 was significantly stronger. Moving on. 6.1, right to a fair trial in civil and criminal proceedings, meaning the first paragraph, or the first point, I'm sorry. In the determination of his civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Judgment shall be pronounced publicly, but the press and public may be excluded from all or part of the trial in the interest of morals, public order, or national security in democratic society, where the interests of juveniles or the protection of the private life of the parties so require, or to the extent strictly necessary in the opinion of the court, in special circumstances where publicity would prejudice the interest of justice. It seems that they're setting up quite an extensive right to determine if a case should be private or open, and if it should be partly or not partly, if it should be in the sense of being logical within a democratic society, which, if anyone is watching my videos chronologically, would know the idea of what is a democratic society. The more you understand it, is that it's arbitrary. It's been decided through case laws. The meaning of democracy does not apply to a democratic standard which the convention uses as their language. That much should be known, and that means it just means one thing. It means that the state has more power than it should within a democratic society, because the convention has decided that they will, for instance, argue that arguments of human dignity do not align with democratic standards. You can do with that as you will, but I will make that a clear case then of not being democratic. But sure, if I'm going to write a test and I need to call it a democratic standard, I'm not going to not do that. I want to get good grades, but things are going to be for no good reason now. People are probably going to start realizing they're applying things which are bureaucratic rather than moral. Moving on, point 2. Everyone charged with a criminal offense shall be presumed innocent until proven guilty according to law. Pretty simple. 3. Everyone charged with a criminal offense has the following minimum rights. A. To be informed promptly in language which he understands and in detail of the nature and cause of the accusation against him. B. To have adequate time and facilities for the preparation of his defense. C. To defend himself in person or through legal assistance of his own choosing, or if he has not a sufficient means to pay for legal assistance, to be given it free when the interests of justice so require. D. To examine or have examined witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. And E. To have the free assistance of an interpreter if he cannot understand or speak the language used in court. Just know, this is slowly diminishing. This is slowly disappearing. With time, I'm pretty sure they're going to officially remove E. If they don't, either it's still ongoing, which even in Sweden, it's becoming more and more discussed if we should remove this right just due to money, but also a question of how we choose to judge immigrants for their integration. But my personal guess is that they're going to have to, just for administrative reasons and political reasons, they're just going to have to remove E. They're just going to have to say straight up, some countries don't even have the money to do that. They could probably make a issue of where it's outside of the EU, even though it is literally within the EU, because I know that EU nations are considering taking away this right. Meaning pretty much immigrants are going to lose more and more abilities to comprehend through the help of interpreters. Now, does that mean that I personally believe that all immigrants have properly integrated? I don't know. But it just means that these ideas established by rule of law are being diminished by the same tactics which rule of law itself seeks to stop. Meaning, if you were to ask me, what is the main component to destroying a democracy? I'll tell you, there's only one thing, and there's nothing more to it. Everything else is supplementary to this fact. It happens in small, successive steps. Look at the US. Look at my videos. I'm going to show it. It's going to be up by the time you see this video, but I haven't made it right now. Everything is done in minute steps until it adds up into a bigger thing, okay? This happened in World War II as well. This happens today in nations which have slowly but surely lost their rights, such as the US. Case laws are usually the main component to how states are able to remove their democratic systems. But anyways, I'm getting out of hand. Let's move on. So, 6.1, right to a trial in civil and criminal proceedings. And then 6.2 to 3 is only applicable to criminal proceedings, aka applicable to the defendant. Now, criterias. I got most of this from Ian Cameron. Shout out to him. He did a pretty good explanation on this. I'll say personally for me, it's also because English is my best language that I've found Ian's book to be the most agreeable to my own understandings or comprehension. However, as I've added before in other videos, he uses the word alien. The word or the terminology of alien is to me anti-intellectual, and it doesn't have any grounding with sound arguments. People use aliens as a term to discuss species outside of our planet. To use that within doctrinal terms, to me, only means one thing, at least to those that excused it in its inception. For instance, Ian Cameron using the word alien does not mean that he holds responsibilities which the creators of this term in these contexts should have. Now, these people, I'm assuming, were alive hundreds of years ago, if not 100 years ago. I'm not going to give them the benefit of researching their names and reigniting their legacies. I hope these people are unknown, and I hope that people don't know who these people are, only that we understand that their inexcusable actions have caused real, specialized, and educated lawyers, and also people within doctrinal texts, to describe immigrants as aliens. And it's stupid. It's very stupid. And I think the most stupid thing is the collective acceptance of this word still being alien, when it should be immigrants. You have no excuse to call someone an alien. In no way. We have so many words for what an immigrant is. There's no excuse. I'm sorry. And if anyone wants to say that alien moves into different categorizations which are either more broad or less broad, I don't care. The word should not be applied for immigrants. It is a word which is outside of planetary systems. And it could be proven, I'm not going to go into it now, but it could be easily proven that these type of words literally indoctrinate people into treating immigrants as if they were aliens. That could be proved. I have no doubt about it. Anyone who wants to use my prompts and look up how alien as a term could indoctrinate even people that are specialized, please do. And get back to me or get back to the people, because it's ridiculous that the word is even used. And it's even more ridiculous that as a collective society, we still don't question it. And I hope that I don't get totally run over for something which I personally believe is the most self-logical idea ever. I don't think anyone could argue with me in this language without knowing what an alien actually means. You couldn't speak to me in this level of English without knowing what an alien actually means in general terms. That in itself disputes your argument against me, because you know what an alien actually is in normal usage. And you probably also know the other words for what an alien means to encapsulate. Moving on. The court seems to have a reputation of making a centralized explanation of their cases or their case laws without stopping Article 6 from becoming redundant as an article applied within case laws. What do I mean by this? The court likes to get deep into issues for every case, which I personally think is fine. However, it within doctrine becomes very confusing because they don't want to admit that the point of the court in ECHR or EKMR is not to have an established case law. It's not supposed to, but in the doctrine I'm reading from Ian Cameron, he's implying that it should be, that the presumption is that it's useful. But if you're watching my videos, you'll know the presumption is that it's going off the margin of appreciation, meaning case laws are pretty much everywhere. If you want to use an argument of case laws, building up arguments for your own ideas, even if it's outside of your own nation but within the court, it could work. You could probably get out amazing arguments about these things, but you need to know that it's not going to be about intuitiveness. It's not going to be about looking at things and seeing how they work. You just need to know by precedents being set, usually in doctrine but also in other sources, explaining these things. Article 6 is one of those cases where most of the things that describe its existence, it's only understandable if you go out and directly read it, meaning these things are not connected through logical dots. You cannot read these articles like I just read it out to you guys and actually comprehend it. They've made it impossible. Ian Cameron himself admits that. For you to understand the terms I'm about to go into, which are central to understanding Article 6, you wouldn't be able to know this just by thinking logically, meaning the logic of Article 6, when being produced with case laws and explanations, it's self-contradictory when being placed in side to side, right? So if you put two different case laws next to each other, especially with Article 6, don't expect it to make sense together. Probably most likely, if not all likeliness, within cases of different countries. So yeah, if you're from one country looking at several cases from your own country, from the courts of ECHR/EKMR, maybe this isn't going to apply in the same way. But yeah, moving on. Criterias, which I have gotten from Ian Cameron: civil rights and obligations, sphere of private law, aka individuals versus individuals, 8.2.1. RF 8.2.1 is a part of the Swedish Constitution, Regeringsformen. This is our chapter 8, Article 2, or we call it Paragraph 2, where we pretty much explain in a list what our parliament is supposed to write laws about. The first point is a civil law, and the second point is individuals versus states, which in Swedish is offentlig makt. It's just good to know that the first point, so Article 6.1, it goes into both. So if you're Swedish and watching this, just know it goes into RF 8.2, which might be confusing for those who are Swedish, because as they know, later on in the next paragraph/article of chapter 8, it'll be explained to us that we should cognitively differentiate point 1 and 2. However, in ECHR/EKMR, you are supposed to see these as things that are together. So it's just good to know that when you're looking into quasi-constitutional and constitutional law, there are going to be points where you need to contradict logics from constitution to constitution, especially if you're Swedish. And then it should be known that these cases which come into Article 6, they don't care if a court is involved, even if a remedy is being established. Meaning cases of, for instance, in Sweden with governmental agencies, aka myndigheter, we have a law which guarantees their independence. Meaning you could say that our governmental agencies sort of have the same rights as courts do, as a precedent within rule of law, where, every court needs to be independent. In Sweden, we have the same idea of where governmental agencies are independent from being scrutinized by, for instance, parliament, but also senates and so on, whatever you call it from your own nation. It's pretty much to say that in individual cases, parliaments are not allowed to jump in and control things. That's what RF 12.2 means, meaning Regeringsformen, chapter 12, second article/paragraph, depending on how you want to see it. Now, this is something that's very special to Sweden. For instance, ministers in Sweden, they can't control individual cases, and they can't politicize these things. However, the court of ECHR/EKMR, they need to still be able to look into these issues. As we're going to get into this further, you're going to realize this is going to be more and more about Sweden. Anyone who needs to learn about comparative law is going to love that. Anyone who wants to know about Article 6, this is still going to be a very, very useful video. But you just need to look into your own nation's ideas as well. Moving on. So we have Article 6.1, meaning the right to a fair trial. Both means in cases of individuals versus individuals, in cases of individuals versus state. And then later on, I'm going to get into when individuals versus individuals and individuals versus states need to be looked into, meaning should these cases in themselves still be applicable? It's just that the first question you need to ask yourself, is it either civil or between a person and a state? Then if the question is yes, you can move on to the next step. But that's the first criteria of getting the right to a fair trial. Now moving on. Bentham v. Netherlands states cannot label questions as administrative and avoid obligations, meaning Sweden had this issue. We're going to get into this as we move on into the video, but pretty much Sweden had this issue where they would usually call things administrative even though they were of civil nature, meaning it ascertained to a person's rights to a fair trial. And what ECHR/EKMR pretty much said as a court was, you guys can't hide behind your own national laws anymore. If a person isn't getting adequate information and adequate contact, we're gonna call you out on it. And Sweden loved to get called out on this in the 80s. I mean, it seemed so at least. But yeah, moving on. Golder v UK, extensive approach taken into the idea of proceedings being what guarantees a fair trial. UK court argued this. However, the court of ECHR then found that this would be meaningless unless the article did not also guarantee to initiate a proceeding as well. This was pretty much about a guy who something happened to him within the prison and he got bruises. He wanted to have a trial be heard, but they said, no, you've already gotten a trial. This is like a administrative issue. Like, we don't care. Also, we don't believe you, blah, blah, blah. And the Court of Europe, or the convention, said, no, this isn't fine. If you were to be able to say this, anyone could get a initial case, then, for instance, be jailed, and pretty much Article 6 is null void. It doesn't matter. If a person can't initiate a hearing, the right is useless. Because that way any country could say that the right doesn't exist, meaning the court doesn't have to look into if a person's case has been heard, which it always has to be within graspable measures. Of course, you can't have everyone at the same time ask for a fair trial. But you need to have a filtration system, which the ECHR/EKMR does have, where they pretty much hear every court case and they make sure to understand when someone is trying to get heard about a thing that's already been taken care of, so that you filter out the cases which you could already understand through either law or through case law. Moving on. Definition of civil rights. See Jakobsson v. Sweden about housing projects and if a hearing about it could entail a civil right, even within an administrative process. This is going back to what I was saying before. Sweden argued to Jakobsson that he can't be heard in an issue concerning his housing because it's an administrative issue, but then the court said that that's not fine. Sweden needs to offer this because it still falls into the nature of a civil obligation. Moving on, question of something is of civil nature. For instance, tax proceedings, expulsions of immigrants do not mean civil. This is where we find ourselves understanding that civil does not mean civil in the intuitive sense or in the logical sense. There are certain things purely based on resources or politics, or if you even want to call it bias, that something civil, for instance, doesn't mean questions of immigrants. I should add, in Ian's book, he used the word alien. Moving on, being charged versus being under suspicion. The ECHR/EKMR court found that they disagreed with national courts on this. Now, I'm guessing margin of appreciation comes into this as well, but the thing is pretty much about the fact of the ECHR court believed that if a person has been called out by a state about something that puts them under suspicion, that is being charged. While the national court argues that that's just being under suspicion, which is not the same thing. But they have come to disagree on this. However, it usually comes down to formalities. Being under suspicion and being charged are, of course, two things that could be differentiated, but they could also be seen as the same thing. Moving on. Reasonable time criteria. Just before I get into it, this is the most prominent question which arrives at the court. It is very important as it also is repeated in almost all instances regarding Article 6. Why? Because if Article 6 should come up, and usually the ideas of what gives a person a right is about the defendant's right. Because a court will always be the state, meaning it will always be a vertical relationship between court and defendant. So if Article 6 should go into the proceeding time being too long, or even too short, usually the remedy is shortening the prison time or making the consequences of breaking the law within this trial less consequential, because the Article 6 will make it considered already paid for through the fact that the person had less rights within the trial, meaning they don't have to, for instance, stay in prison as long or pay the same amount of, fine, whatever. It's also then important to understand that in, for instance, Sweden, We have hekta, which is when you take someone's free right of movement away under the time of being suspected of having committed committed a crime. Meaning, there are cases where people, for instance, have lost their free movement, aka being imprisoned, and then they've been released, meaning it was maybe a fair trial from that sense, but then it has to be fair also by applying, I think it was Article 14 or 12, having proper remedies. But yeah, the most important thing to know is that the proceeding time is usually what Article 6 comes down to. That's just volume-wise. Obviously, if you want to understand it as a student, there are more things about it. And, they could throw at you a test where it doesn't even matter about the proceeding time. But it's just good to know. If you want to argue how consequential each part is, this is probably going to be the most consequential in practical instances. The first thing you need to look into then of the criteria of reasonable time is looking into the complexity of the case, meaning was the case simple enough where it could have been shorter? 2, the conduct of the applicant. Was the applicant making the procedure take any longer? Also, you could maybe argue in some instances, did the applicant make it easier? Meaning, did the court make it harder than it had to be, despite the defendant being more than agreeable? The relevant authorities involved, meaning administrative things, that could go back to the complexities, but also into how things need to be proceeded. Time may be more in need if, let's say, a certain part of the government was involved or whatever. What was at stake for the applicant in the dispute? Now, this could be several things. It could also come down to what they've actually been accused of. Does this person lose their ability to have a proper life? Now, this is in the question of either if they were guilty or innocent, but also even if they're guilty, this could still come into question. It's good to know. The best example is like an athlete being accused of something and then losing their prominent years as an athlete. That is something that is at stake for the applicant. So meaning if they are found not guilty, that would be a huge portion of this, if you ask me. Maybe the court wouldn't find this in the same way, but I think it should. I mean, if an athlete has been accused of something and then years go by, because court cases even in its shortest form can take years, okay? Meaning an athlete could have lost half of their prime years. Now, this is an example. I do not want to invite people to say that women are accusing men of being raped when they haven't been raped. That's not why I'm using this example. I'm using this example because it's the most logical way to explain to my listeners how this works. Do not take this as an invitation to say that Mr. S believes that Kobe or, I don't know, whoever the else proved the fact that women lie about being raped. That's not the point. I'm just speaking to how things work within law. I'm trying to be as objective as possible, but I need to make it clear. I need to draw the line. If any dudes are trying to make this into their argument, you ain't using my name. Moving on. A tribunal responsible for case must be independent and non-corrupt. This goes back to what I was explaining before, where the court usually establishes a relationship with each nation's own courts. However, if there should be a case where the court doesn't sort of have a proper relationship with the tribunal which has decided something, and for instance, Sweden with our myndigheter, our state agencies. Now, I'm pretty sure these agencies, the Swedish agencies, have established a relationship with the court due to the nature of how Sweden usually breaks the articles through this specific nature of Swedish constitutions, or the Swedish Constitution. But otherwise, if there should be a special court which has made a decision which has to be looked into, the court has to assume that they don't know anything. Meaning, going back to, let's say, the reasonable time criteria, if a new organ should be put into question, a new tribunal, the criteria for the complexity of the case, even the question of the relevant authorities, could have large implications. Also, what is at stake for the applicant in the dispute. If they don't have the court properly looking into how the group which decided their case sort of functions, if they can't look into that, that would put the point 4 into risk of not being accomplished. But yeah, if you want to understand these things, it's important that you look into your own country then. This is usually going to be out of my own control. But if you want to use my prompts to look into it, you should. Moving on, more on civil rights and obligations and evidence. Eriksson v. Sweden, regarding the right to be heard by a court regarding social services. Even if a family issues an administrative case, it still falls into the rights of civil rights and obligations, meaning Sweden was neglecting the right to a fair trial because they weren't hearing these things within a court context. Because when a government agency makes these decisions, then the question becomes who is checking their actions? Who's making sure that they're not doing the wrong thing? Meaning, are they being protected? Now, this also falls into Article 8, right to a private life. But then also Article 6, whenever the government agency tries to argue that they didn't have obligation, the court will argue, no, you do. Borgers v. Belgium, a police officer brought in evidence which a court refused to be objected, meaning the police officer came in and said, I have new evidence, and this evidence changes everything. And we're not even going to let the defendant dispute. Moving on, anonymous witnesses. I'm not even going to try. Read Germany. So it's just a question. These 3 points came up in this case law about anonymous witnesses. The first question is, was there a good reason for non-attendance of the witness? 2, is the evidence of the non-attending witness the sole evidence used to convict the defendant? And 3, proportionality test. Did the court secure proper and realistic remedies for the handicap effect of a non-attending witness that a non-attending witness could have on the defendant's right to a fair trial? Pretty much, you could have then anonymous attendance. I'm sure with cases of criminal organizations, this can be pretty easily argued. But yeah, good to know. Moving on. Now, I'm about to show you guys now a image from Ian Cameron's book. Due to legal reasons, I have to explain why I'm doing this, to what extent, and why it is I deem it necessary that I directly put in his own sources. Now, to begin with, I'm trying to find when this version was published, but I'm just going to read out the ISBN because I just want to be legally protected. Or you know what? I'm just going to write it down. But as I'm writing it down, I can explain why I did this, because as you guys probably know, I usually don't do this. It's because I found it that Ian had put this information down pretty clearly, and I appreciate that, and that is like the primary reason why I wanted it to be here. But also because I found that his footnotes, considering how organized his ideas were, the footnotes were quite disorganized. So I would have to assume this was his own organizing of the 6 points. However, each point doesn't equate into one footnote. You have the ability to look into this image yourself. If Ian should want to contact me to ask me to take this part down, I will, even if there is no legal obligation. However, I find that Ian did a really good job, just for everyone's sake, to simplify this. And that's why he's here, right? That's why we need people like him. So thank you, Ian. But yeah, let's look into the 6 points. And let's explain how these 6 points have gone into the things we discussed before, how if any of these 6 points could be new. But yeah, let's just read it out. There are a number of legal disputes which most convention states would regard as wholly or largely belonging to public law, but to which the court has stated that Article 6.1 can apply. These are disputes concerning the rights to inherit, retain, or use property. 2, disputes concerning the right to engage in a particular sort of economic activity or to obtain a permit which is of significance for such activity. 3, disputes over the right to receive damages from the state for unlawful conduct. 4, disputes over the right to social benefits, where these are expressed in terms of a right. 5, disputes over family rights, such as parents' right of access to children taken into care by social welfare authorities. 6, disputes over questions of employment in the public service, except for disputes concerning a small group of public employees who yield a portion of the state's sovereign power, and then only during the period of their employment. Pretty much, if I've understood correctly, if anyone wants to correct me, if not Ian himself wants to correct me, this is when countries try to argue that things have been done through the agencies of the government, meaning a trial doesn't need to happen. If this is incorrect, please correct me, but this seems to be how the Swedish context works. He also writes below, Sweden has lost a number of cases concerning the lack of court appeal possibilities concerning the civil rights during the 1980s. For instance, Jakobsson v. Sweden. Or no, sorry, Eriksson v. Sweden and Jakobsson v. Sweden, which I don't know where it is. Oh no, wait. Jakobsson v. Sweden is here, right? No, that's Article 7. I don't recall where I put Jakobsson v. Sweden, but he should be somewhere around here. Or did I accidentally... No. Okay, guys, just forget. Jakobsson v. Sweden. Forget it. If anyone could maybe explain it in the comments. Maybe I messed it up. Eriksson v. Sweden is a good example regarding the right to be heard by a court regarding social services. This is when a question of then public law. This is where the Swedish court tried to argue that it's public law, meaning we don't need to hear your case. If I am incorrect, everyone roast the shit out of me, please. Let's keep it real. But yeah, thank you for watching.